A real estate transaction in Canada can sometimes create a tax surprise that most buyers and sellers do not expect, especially when the seller is not a resident of Canada. In one Tax Code of Canada case, a buyer purchased a condominium in Toronto for about $368,000. The seller appeared to have connections outside Canada. Under Canadian income tax law, when a non-resident sells certain Canadian property, including real estate, the buyer is generally required to withhold and remit a portion of the purchase price to the Canada Revenue Agency unless a certificate of compliance is obtained. For most residential real estate transactions, that withholding is 25% of the purchase price, which is the cost to the purchaser. For certain types of property, including depreciable, taxable Canadian property, Canadian resource property, and timber resource property, the withholding rate increases to even 50%. In this case, the buyer relied on a short statement from the seller indicating that the seller was a Canadian resident, and based on that statement, the transaction closed and the full purchase price was paid without any withholding. Later, the CRA reviewed the transaction and issued an assessment. The CRA took the position that the buyer should have withheld approximately $92,000 under Section 116 of the Income Tax Act. The matter went to the Tax Code of Canada. The court considered whether the buyer had made a reasonable inquiry into the seller's residency. The evidence showed several warning signs. The seller had a California address. The documents were signed in the United States. The property was used as an investment property. The court also examined the document the buyer relied on. It was a brief statement and it was not sworn under oath. The judge concluded that this was not sufficient in the circumstances. The court found that the buyer had not made enough inquiries and remained liable for the withholding obligation. The appeal was dismissed, unfortunately. This case explains why buyers and lawyers take a cautious approach. If the withholding is missed, the buyer can become responsible for the tax that should have been withheld, along with interest and penalties assessed by the CRA. Now, this is where many sellers get surprised. When a non-resident sells Canadian real estate, lawyers often hold back 25% of the purchase price unless the CRA has issued a certificate of compliance. That certificate is requested by filling forms such as T2062 or T2062A, providing the details of the transaction, including the purchase price, adjusted cost base, and supporting documentation. If the certificate is issued before closing, the CRA sets what is called a certificate limit. In that situation, the withholding is reduced and is calculated as 25% or in some cases 50% of the excess of the purchase price over the certificate limit. Without the certificate, the default position is withholding on the full purchase price. It is also noteworthy to understand that selling costs such as legal fees and commissions cannot reduce the withholding at the time of closing, but they can be claimed later when the seller files a Canadian tax return. In many cases, the actual Canadian tax is much lower because tax is calculated on the net gain. Any excess withholding can be recovered after the return is filed. There are also situations where a tax treaty between Canada and another country may reduce or even eliminate the Canadian tax. If the property is treaty protected, the buyer may not be required to withhold, but specific steps must be taken, including notifying the CRA within the required time frame and providing the relevant details. This is why timing matters. When planning starts close to the closing date, the certificate is usually not ready and the withholding becomes difficult to avoid. That often means funds remain in trust while the CRA processes the application. When planning starts early, at the listing stage or even when the offer is signed, the withholding can often be reduced or managed before closing. My name is Amandeep Singh and I am a CPA with Cloudiverse CPAs in Burnaby. We help clients plan these transactions early so the CRA requirements are met and cash flow is better managed. In many ways, this is similar to using Google Maps before starting a long drive. When the route is reviewed and in advance, the roadblocks become visible and better decisions can be made along the way. The court's decision allows that these rules are applied strictly, and early planning can make a meaningful difference. Thanks for watching, and I'll see you in my next video. Until then, bye.